of Ohio versus Isabella Rotundo, cases 25 CR 00085 and 0000581. In this matter, on case number 085, the defendant originally pled guilty on July 14th and was then had filed for intervention in lieu of conviction. Same in case number 25 CR 581. She was referred then for an intervention plan, and then there was a motion to terminate intervention in lieu of conviction filed on December 17th in this matter, and that alleged several violations, that being of Rule number 8, Rule number 11, Condition 8, Rule number 11, Condition 7, and Rule number 11, Condition 4. We were last here for purposes of a probable cause hearing. It's the state's understanding today that the defendant would waive the right to have a final hearing and proceed to a change of plea in this matter. She is present today with her counsel, Mr. John Fatika.
Thank you. Mr. Fatika, is that correct? What is the defendant's intention at this time regarding the final hearing on the motion to terminate intervention in lieu of conviction?
Good morning, Your Honor. That is correct. We'd like to waive the final hearing, accept responsibility, and resolve the violations today.
Thank you. Cindy, both PVs are the same, just one was with a warrant, one was without a warrant, right?
Yes, sir.
Okay. Well, Ms. Rotundo, you have been charged with violating the conditions of your intervention plan.
Welcome back, everyone. Today we're diving into the Ohio versus Isabella Rotundo case, two separate cases wrapped up in one dramatic courtroom session. On one hand, we have case 25 CR 00005, and on the other, Case 25 CR 000581, both involving intervention plans, alleged violations, and some serious stakes for the defendant. Isabella originally pled guilty back in July, but things took a turn when multiple violations were flagged, ranging from missed grief counseling to unresolved warrants and unfulfilled treatment requirements. Stick around because we're about to witness her plea, the judge's breakdown of her violations, and a sentencing that could change everything. You won't want to miss how this unfolds, especially the emotional moments from the defendant and the legal strategies played out in real time. Let's get into it.
That were originally put in place back on July 14th of this last year. Specifically, it's alleged you violated 4 separate rules or conditions. The first is Rule 8, which requires you, or should say prohibits you from using, possessing, or having under your control any controlled substance not prescribed to you by a licensed physician. It's alleged you admitted to using Suboxone on December 10th, that you admitted to using Suboxone on a prior date. It's further alleged 3 violations of Rule 11. Rule 11 requires you to comply with all special conditions that are set forth by the court. The first special condition was condition number 8, which required you to attend grief counseling. You had not done that at all. Second special condition was number 7, which required you to resolve all outstanding warrants. You had not done that. And the third special condition was that you attend 3 AA meetings a week and obtain a sponsor, and you had not been attending 3 AA meetings a week. Now, you have the right to have a final hearing regarding these allegations. That's a hearing where the state of Ohio would have to prove the actual merits of what they're alleging with these violations. Now, you can have that hearing, but you can also waive the hearing and plead guilty to the violations. And it's my understanding, based on what your lawyer had just indicated, that that is your desires to waive the hearings and plead guilty to the violations. Is that correct?
Yes, Your Honor.
Well, before I can accept your waiver and your admission, I need to make sure you understand the potential penalties you face if you are found to have violated your community control sanctions. If in fact, or I should say your intervention plan, if in fact that did occur, the court would lift or vacate the stay of criminal proceedings that were initially ordered by the court. I would find you guilty of the charges in each of these 2 cases, and then we would proceed to sentencing in each of the 2 cases. And in case 25 CR 085, you pled guilty to 2 felonies of the 5th degree, so you can be sentenced up to a maximum of 2 years in prison, fined up to $5,000. It's also a probationable offense that you can be put on probation for up to 5 years with a variety of different conditions that you follow. In case 25 CR 581, you pled guilty to one felony of the 5th degree. That would be punishable by a maximum prison term of 12 months in prison, $2,500 fine. It also is probationable as well. So do you understand the potential penalties and the consequences that you face if you are found to have violated your intervention plan?
Yes, Your Honor.
Well, having been so advised, what do you want to do at this time? Do you want to have a final hearing, or do you want to waive the hearing in both cases and plead guilty to the violations?
We'll waive the hearing in both cases, plead guilty.
Very well, then, as the allegation that you violated Rule 8 by using Suboxone, what is your plea to that?
Guilty.
As the allegation that you violated Rule 11, Condition 8 by not attending grief counseling, what is your plea to that?
Guilty.
As to the allegation you violated Rule 11, Condition 7 by not resolving outstanding arrest warrants, what is your plea to that?
Guilty.
And as to the allegation you violated Rule 11, Condition 4 by not attending...
Here's where it gets interesting. Isabella was charged with multiple violations of her intervention plan. Rule 8, which forbids the use of non-prescribed controlled substances, was violated with admitted Suboxone use. Then, there were 3 Rule 11 violations: failure to attend grief counseling, unresolved warrants, and not attending the mandated 3A meetings. Essentially, the court is laying out a pattern of non-compliance, but notice how the judge clearly explains the right to a final hearing versus waiving it. This moment is crucial because it frames the defendant's choices: take responsibility and plead guilty now, or face the state proving the allegations later. It's a classic courtroom tension moment, and it sets the stage for the judge's measured but firm response to repeated violations.
3A meetings a week, what is your plea to that?
Guilty.
All right, the court will accept your pleas of guilty, find that you did violate the conditions of the intervention plan that was imposed in both of these cases. At this time, the court is going to lift the stay of criminal proceedings. I'm going to find the defendant guilty in case 25 CR 581 of count 1, possession of a fentanyl-related compound, a felony of the 5th degree, in violation of 292511 of the revised code. Case 25 CR 085, I'm going to lift the stay of criminal proceedings as well, find the defendant guilty of count 1, possession of heroin, a felony of the 5th degree in violation of 292511 of the revised code, as well as count 2, possession of a fentanyl-related compound, a felony of the 5th degree in violation of 292511 of the revised code. The court already has a pre-sentence report and investigation, drug and alcohol evaluation. So, Mr. Fatika, is there any reason not to go forward with sentencing in both of these cases?
No, Your Honor.
Is there anything you'd like to say on behalf of your client?
Yes, Your Honor. Ms. Rotundo has been at the Lake County Jail for 36 days as of today. As you may recall, at the first hearing, she was in a wheelchair. She is making progress. I met with her last week. She's seems to be thinking much more clearly. She's not had an opportunity to participate in residential treatment. That's what we're asking for today. She's been in medical isolation at the jail for this 36-day period. It's been rough on her. She's been going through some very harsh withdrawal symptoms. But again, we would ask that she be given an opportunity to participate in residential treatment.
Thank you. Mr. Tondo, you have the right to address this court before your sentence, and you can say anything you like. Is there anything you'd like to say in either of these cases before sentencing?
I would like to apologize and take full accountability and ask for the opportunity to get residential treatment so I could get back on track and do well and be there with my child and just do things right. And I'm sorry for letting everybody down, and I just apologize. I apologize.
How are you feeling now?
I'm feeling better. I'm just feeling upset. I'm just disappointed in myself, and I apologize.
I get that, but I'm talking, not that I'm not interested, but I'm just on physically, your physical health, how is that going?
Physical health?
I don't want you to divulge anything you don't want to divulge.
No, it's
but just-
okay. The physical health, it's been hard. It's been really hard, especially being on the lockdown and everything. And I saw a nurse.
That's because of medical issues?
Yeah, medical issue. Yeah, and they haven't cleared me yet for that. And it's been, like you said, 36 days in a medical lockdown. So I'm trying to figure that out.
Now, the stakes are real. If the court finds these violations proven, Isabella faces the lifting of her intervention plan's protections. In case 085, we're talking 2 fifth-degree felonies, up to 2 years in prison and fines up to $5,000, with probation options up to 5 years. Case 581 adds another fifth-degree felony, 12 months in prison, $2,500 fine, also probationable. This is why the decision to waive a final hearing is so significant. She's essentially choosing to face the consequences head-on rather than prolong the legal process. This part of the video highlights a critical teaching point about courtroom strategy. Sometimes owning up and pleading guilty can influence the judge's discretion on sentencing, especially with demonstrated remorse and willingness to engage in treatment.
And get off of that, because it's not, you know what I mean, helping anything per se. But I'm trying. That's all I can do. That's all I can do.
Mr. Fatika, is there anything else that you want to say?
No, thank you, Your Honor.
Ms. Linden for the state of Ohio?
Thank you, Your Honor. Your Honor, what we discussed in chambers we feel would be appropriate with residential treatment. She does have on case number 085, 38 total days, 36 on the PV, and then on 581, 31 total days, 27 on the PV.
Thank you. Well, the court reviewed the original pre-sentence report and investigation, the drug and alcohol evaluation. I considered the facts and circumstances of the offenses involved here, the nature of these offenses. I've also considered what's been said here today. I considered the nature of the violations that brought us back here today as well. All this is considered in light of the purposes and principles of felony sentencing set forth in 292911. So the factors in 292912, nothing stands out factually indicating the conduct is more or less serious than what normally constitutes the commission of these offenses. As for recidivism factors, the court notes there is a prior criminal history. So these are our first felony charges. It does appear that the case in 25 CR 085 occurred while she was on probation in Mentor Municipal Court. They were also committed while she had warrants issued for her for failing to appear in court for traffic offenses. Drug abuse problem obviously relates to the commission of the offense. It seems like, however, the defendant wants to get help and treatment. for recidivism factors, indicating it's less serious. There's no juvenile delinquency adjudications. Criminal conduct didn't start until even, when she
Watch closely as Isabella enters her pleas, guilty on all counts, from Suboxone use to missing grief counseling and 3A meetings. The court accepts these pleas and formally finds her in violation of her intervention plan. Notice the judge's procedural precision here. Each plea is acknowledged, each violation recorded. For viewers, this is a clear demonstration of how courts handle intervention plan violations. Meticulous, step-by-step, leaving no ambiguity. This is also where courtroom tension peaks. Isabella has admitted guilt, and the judge is now ready to move into sentencing, weighing both the severity of violations and potential for rehabilitation. The pacing here keeps viewers on edge, knowing that what comes next could significantly affect her future.
When she turned 18, like in 2016, it didn't occur until 6-7 years later. Something happened around that time.
It started as soon as my dad passed away. He passed away in August of 2021, and I got arrested for the first time in December of 2021.
Who's Dustin Dowen?
Dustin Dowen, the father of my child, that just destroyed my life completely.
Well, it seems like maybe there's an issue there as well. But
absolutely.
because I see his name in the very first entry here, and you're not supposed to have any contact with him, and you're still having contact with him.
That's why I'd like to just stay as far away from him as possible and just...
You're going to have to.
Absolutely.
And if you don't, it's going to be a violation, because it's going to be an order.
Right.
So, court also finds defendant is amenable to community control sanctions. Prison is not consistent with the purposes and principles of sentencing. Therefore, in each case, the court is going to place the defendant on community control sanctions for 2 years. It'll be 2 years total, so it's a concurrent 2-year community control sanction. Same with the counts in the one case. I'm going to order, in case 25 CR 085, serve 83 days in jail with 38 credit. In case 25 CR 581, you serve 77 days with 31 credit. These 45 days for you to start immediately get into the jail treatment program. Complete that successfully. Follow all aftercare recommendations. Upon completion of that, you are to be released as soon as the bed's available and enter the residential treatment center at either. It's either one we're going to, right, Cindy? Oak House or Nevaeh?
Yes, sir.
Oak House or Nevaeh Ridge. Successfully complete that program, follow all their aftercare recommendations. Further conditions, you're not to use any drugs or alcohol, and that includes no medically assisted treatment. We're not doing Suboxone or methadone. Submit random urine screens. They have to be negative. 3 AA meetings a week. Proof of 3 AA meetings a week. Attend them and provide proof. Have a sponsor.
Here's a moment that humanizes the defendant. Isabella's attorney, Mr. Fatica, emphasizes her time in jail, 36 days in medical isolation, and her struggles with withdrawal symptoms. He requests residential treatment as an alternative path. This is a pivotal VO moment for commentary because it illustrates the tension between punishment and rehabilitation. The court is being asked to balance public safety and justice with compassion and opportunity for recovery. For viewers, it's a reminder that every case has layers. Beyond legal technicalities, there's a human story unfolding. Her attorney's arguments also show strategic positioning, emphasizing medical hardship and commitment to recovery to influence the judge's sentencing decision.
Are you able to, I know you've got some issues now, but there's no reason you can't work once you're
I'm not sure I don't see a reason
Yeah,
why, but they still have me on a medical lockdown. I'm not
So
sure.
you're to obtain and maintain full-time employment and/or education. If you want to go to school, get some type of training, whatever, you can do that as well. But a full-time basis, once you get out, and back on your feet, you should keep yourself busy on a full-time basis, working or going to school or some combination of the two. You have one doctor and one dentist. This is the same conditions that were on the intervention plan that can prescribe you medication. One pharmacy. If you have a specialist, that's fine too, but probation needs to know who the doctors are that give you prescriptions. You can only get them from those doctors. You can only fill them at one pharmacy. They need to know where that is. You can sign whatever releases they need to have you sign so they can speak to those folks or counselors. You're to attend grief counseling. You just even acknowledged here today that's what caused all this. You're not to have any contact with Dustin Dowen, aside from whatever may be ordered by juvenile court or domestic court, if they require that for some type of contact with the child, then that's going to have to happen, just to facilitate that. Otherwise, no contact. And no contact means no contact. Not just face-to-face talking, it means emails, messages, phone calls, messages while you're in jail.
Okay.
It means not having anyone else have contact that you're directing to have contact. You can't have your mother reach out to him and say something, or friends contact him.
Okay.
No contact. Pay your court costs and supervision fees. Take all medications as prescribed. Stanley, anything else that I'm missing here I should think about?
Your Honor, would you like her to continue to pursue resolving those warrants?
Oh, yeah, absolutely. Those need to get resolved. I mean, I know you can't do it right now, and you're not going to be able to do it maybe, but you can't be on probation and have warrants out for you. So those need to get resolved, and however they get resolved, they get resolved. It's not going to impact your probation. If you feel it's in your best interest to plead guilty to those outstanding, if there even are charged, I think they're traffic, then you do that. That's not going to affect your